It's day 31. We are in week 8 of the retrial of Karen Read. And what we learned in court yesterday is that we are very close to being done. The defense is on their last witness. What does that mean? Well, they're not going to call Karen Read to testify. We kind of knew that. They're not going to call Trooper Proctor to testify. And we had heard that, but seeing is believing. And it looks like no one is going to call Trooper Proctor to testify. So we will be done with Dr. Rentschler today. That's where we're at with this case. And then there needs to be a charging conference. That is the jury instruction conference between the jury is charged with the duty of rendering a verdict. So that will be instructive. I hope that it is also streamed so we can see what they are arguing over the different jury instructions. At that time, we will hear more discussion about the jury instructions the defense is asking for, like the instruction regarding necessary witnesses, sometimes called missing witnesses, like the instruction regarding the hoodie and what was asked of Dr. Wolf before the jury about that. Some of those things we will hear in the charging conference and see what the final set of jury instructions will look like. The defense is not asking for a third-party culprit instruction. They didn't ask for that last trial either, so that's not new. The evidence hasn't been developed that way in this case at all.
What conclusions or opinions did you reach or could you reach after reviewing the totality of the results of the paint transfer test?
The paint transfer test, all it can show is the approximate area, of where the arm was covered in paint as the surrogate jammed his elbow in and rolled against the taillight cover. So it tells us nothing about what may have actually occurred, how the lacerations were actually, or the abrasions were produced. It doesn't talk about the kinematics of the arm to actually cause those abrasions. All it does is just say, under this specific condition, if someone was to stand there and then shoot your elbow forward and lean in, you would get paint on this part, this approximate part of the arm, because we don't even have any measurements for it. That's the only thing that test demonstrates, and that's the only test that was conducted to look at the interaction between the arm and the Lexus in this case.
Did you reach any opinions and conclusions regarding whether the physical evidence is consistent or inconsistent with the injuries to Mr. O'Keefe's right arm?
I did, yes.
And what are what's the basis?
The basis is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the rear of that vehicle.
Do you hold that opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
At the morning break, we have gotten through the full direct examination of Dr. Rentschler. Yesterday, we saw that Brennan said he had about an hour, he thought, of cross-examination. That should be done before lunch then. The defense may rest by the lunch break. They may not. Who knows what is going to happen from here, because there may be substantial redirect, there may not, depending on cross. I expect this cross will be shorter, but again, we will see. I think that the defense with this witness did a very good job of using visuals. Even though we know this is a pared down PowerPoint, the jury doesn't know that. I think the visuals they used were helpful to explain to the jury why the injury to John O'Keefe's arm and the injury to the back of the head are inconsistent with the Commonwealth's theory of the case. And I think the defense did a good job of highlighting that what Rentschler was testing is what Welcher did in his test. Not that Rentschler was trying to solve the problem. He talked about being asked to figure out if this was consistent in his testimony yesterday, and he said that it wasn't. But now he was saying, look, I'm trying to test what Welcher did and see if Welcher's test with the paint and holding the cup and hitting the car is consistent or inconsistent with what we know from the damage to Karen Read's vehicle and the injury to John O'Keefe. Because the thing that we know for certain in this case is what the injury to John O'Keefe is. And I think that it is in question for some, but the damage to Karen Read's SUV as it purports to be, whether you think that the taillight was less damaged or more damaged, there is some damage to the taillight. But as the Commonwealth purports it to be, there is damage to the taillight on 2 different levels of that taillight. So is the injury to John O'Keefe and the damage to the taillight as it purports to be in the Commonwealth's theory consistent? And as they walked through this expert's opinion, it was, this is not consistent and this is why. And we saw, I think, more visuals on that. And then we saw the slowing down and the breaking down of how Rentschler did his testing.
When you were traveling out to testify last year, you had phone conversations with the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yeah, there was one right before my qualification, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Mm-hmm. Was there any discussion on how you could portray yourself as independent?
I don't believe there was.
So you don't believe?
Yeah, there was no.
They had a lot of conversation about how to explain who hired them without saying who hired them, which is a very unusual circumstance.
No need to.
That's not the question. Details matter. Was there any attempt?
Is that a question?
So the objection sustained. I'm going to strike that, folks, okay? Questions, Mr. Brennan?
Was there any attempt in your conversations to portray yourself as independent as far as your arrangements were concerned and coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation, assistance getting here?
They provided a ride to and from the airport, yes.
And did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took their ride. If I wanted to appear independent, then I would have taken an Uber.
Did you have a conversation about that you were thinking about taking an Uber?
It didn't even cross my mind, sir.
And then after you testified, did you stay independent?
What do you mean independent?
Well, did you have any bias in you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Home.
Well, I was waiting for my ride, and to get back to the airport, they had to take other people, and so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
Had a ham sandwich.
God damn it. There's a ham sandwich. They aren't even muffins.
Did you testify at some point that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich? Or did
you have
more go
chips?
on?
Wait, were they Pringles? What kind of chips did you have? What's your favorite kind of chip?
People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you have awesome shooters and talk to awesome people? This line of cross-examination after the direct has just gone sideways into ridiculousness. We are just starting to get into what testing Rentschler did in the cross. We had a thorough investigation of ham sandwiches and who Rentschler ate lunch with and whether or not it was awesome and if he laughed when people made jokes and if he stood in the corner and who paid for his transportation and whether it was an Uber from the airport or not. We thoroughly investigated that area of questioning. And Rentschler remained steadfast that I haven't changed my opinions in this case. Those things do not change the examination that I did. So the questions that might impact the jury, I think, get lost under the snark about sandwiches. The jurors might disagree. If the jurors are looking at this witness as a hired gun for the defense who's just going to come in and say whatever the defense wants, they might feel differently. And we often see that in prosecutions where people feel that the fancy paid experts from the defense are the hired guns. I don't think that holds in this case because we're not looking at hired witnesses versus non-hired witnesses, which is truly a misnomer, but jurors don't often see it that way because oftentimes the experts for the Commonwealth are from the state crime lab or from law enforcement, and they're paid for their jobs on salary, just like experts for the defense are paid by their company on salary. But the juries often see it differently. When you have, the crime lab analyst who's like, the cases show up and I do my job. They see them differently than hired experts who are chosen. But that's not the case here. And Brennan seems to forget that. The case here is that you had an expert from law enforcement, chose not to use that expert from law enforcement, and went out and picked another expert and paid them multiple six figures. So I think you lose the steam of these experts were paid by the defense when we know how much your experts were paid. And I think the number of how much they are paid undermines that argument. All the experts in this case were paid to come in and testify. I think it just neutralizes the serve of, oh, you just paid people to come in here. It really does, because it was a staggering number. And I've never seen anything quite like that. But what we're seeing today is that Brennan's not even asking about Rentschler's testing. And we've seen that in other cross-examinations too. I was critical of Alessi in a cross for the same thing. We're not talking about what the expert did. We're talking about the expert. Are we going to talk about Dr. Rentschler's testing? Or are we not? Are we going to continue saying, oh, but you didn't see an MRI of John O'Keefe's arm, so you don't know if there was ligament damage or muscle damage? I don't know if that helps the Commonwealth move beyond the testimony of Dr. Rentschler, which is not helpful for them. The testimony of Dr. Rentschler is these injuries to John O'Keefe could not be sustained by being struck by a vehicle. And he went through a couple of different options of being struck by a vehicle and falling backwards, being struck by a vehicle walking and falling backwards. He went through a couple different scenarios and said, you can't get this injury pattern from a collision with the car. And he went through and talked about the different ways that the taillight would send out fragments and why those fragments wouldn't cause the injury to John O'Keefe's arm. And I think the visuals on that were incredibly helpful. And jurors will remember the visuals of the arrows pointing at the different directions of the injury to John O'Keefe's arm. Because in all the videos we saw of the taillight is moving in the same direction out and away from the vehicle.
Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Leslie needs to, I didn't mean to interrupt.
We should get you guys to Brennan first.
After the defendant rests, we will not be calling any witness.
What? They're not calling any rebuttal witnesses? At the end of day 31, not only are we done with the defense case pending the PowerPoint of Dr. Rentschler being admitted into evidence, which is going to be discussed overnight, but the Commonwealth at the very end of the day said, when the defense rests, we are calling no further witnesses. Isn't that a surprise? There are so many things that Hank Brennan fought for in this case and then just kicked the doors open on anyway. I wonder if the ARCA testimony changed his mind, or is it the x-rays? Is it better to not put Welcher back on the stand to get excoriated over the fact that there are x-rays? I wonder if the Commonwealth didn't anticipate the defense bringing in the x-rays because it was glaring. It was one of those moments where all 50,000 of us in here went, what do you mean there's fucking x-rays? We were told there were no x-rays. And now there's x-rays? Either way, the Commonwealth fought like hell to allow that testimony to be split up. And the defense fought and fought to keep that testimony from getting split up. The Commonwealth won that fight. And then they're like, nah, we're good. So at the end of 31 days, we're at the end of evidence at the Karen Read case. That's it. All of the evidence is in. So what's left? Well, the charging conference, which is the conference where they go over the jury instructions, the instructions that the jury is going to be charged with. At that hearing, we will hear about what instructions the defense is asking for, the Commonwealth is asking for, how they'll be structured, what lesser included crimes are going to be offered with count 2 or not offered with count 2. There might be discussion of that. There will be discussion of that necessary witness / missing witness instruction. We'll talk about that more tomorrow because that will come up in the conference tomorrow. And we know that Alessi is going to renew his request for a further instruction about the Commonwealth's representation during Dr. Wolf's testimony of the holes on John O'Keefe's hoodie. Those are the things they're going to talk about at the charging conference. So tomorrow's going to be a half day, if not less. And with tomorrow being a half day, they will just go through the jury instructions and finalize them. And then on Friday, they will do closing arguments. The court will probably take about an hour to read in the jury instructions. It might be a little longer than an hour. And then an hour to an hour and a half of closing each. So maybe 3 hours of closing, an hour and a half in jury instructions. That's a half day. And then the jury will have about a half day to deliberate, maybe a little less. And the jury will have to decide if they want to deliberate a little longer on Friday or take the weekend. Because last time, everyone thought this was going to be a real quick case. And the jury was out deliberating for an extensive amount of time. And we learned well after the fact that the jury was mostly deliberating regarding count 2. Count 2 is the involuntary manslaughter. Count 2 has lesser included crimes. The jury instructions are complicated as to count 2. They absolutely are. And we didn't see the attorneys address count 2 at all in their closing arguments last trial. And I think we will see more mindfulness around how count 2 is discussed from both teams when we get to closing. I am stunned that we got to the end of the day and we are done with evidence. So while the defense did not rest in front of the jury, the defense has, for all purposes, rested, pending one item of evidence getting entered into. So when the jury comes back Friday, the defense will formally rest. The prosecution will say that they have no rebuttal. The court will read the opening instructions. Then you will get closing arguments, then the closing instructions, then the jury will deliberate. We're at the end of evidence. That was a quick turn of events. A number of you have asked, what is the process for closing argument? The prosecution goes first, then the defense, then the prosecution. The prosecution bears the burden, so they get to do their closing, the defense closing, and then their rebuttal. Sometimes people call it their opening closing, the open close, and then, but we will see. That's the end of evidence in the Karen Read trial. 31 days of evidence, 8 weeks of trial. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.